Also joining us at this time, Kapil, Madan, Ashutosh, Srivastava are with us. Good morning, gentlemen. Namaste and Jai Hind. We also have Sanjay Rana, political analyst, with us. So let me ask you, Ashutosh Srivastava, where do you stand on the legality of this all? If there is no legislative assembly, does the LG have the powers? And if an act has to be amended, then shouldn't it be an act of parliament? Is that not what is mandated by the constitution?
See, what I understand, and as per my opinion, Article 368 of the Constitution gives, complete powers to the Parliament to make amendments, and accordingly, the amendments have been carried out. There are procedures laid down, and all these procedures have been followed by the Parliament and by the President of India. And I'm sure the same thing will come up in the order which we are expecting today, and as the citizens of this country, we feel that the abrogation of Article 370 will be upheld by the Supreme Court. And there have been many transitions. Even if we see the submissions of Karan Singh, the ruler of J&K, being the son of Hari Singh. His proclamation was also like that. Those proclamations were also considered, where it was clearly stated on 25th November 1949 that, which clarifies that the sovereignty of J&K was transferred to the dominion of India. And also, if we consider Part 21 of the Constitution, which talks about the temporary arrangements being made, and this has also been kept under under Part 21 of the Constitution. So it was not a permanent any amendment being made. Yes, that since it was not further confirmed and finalized, and accordingly it had the temporary nature, and accordingly this Article 370 earlier, if we know years back, also it was discussed and it was to be abrogated, but unfortunately it could not take place. So there are provisions, and as per the provisions only it has been done. So basic issue will be Article 368, whether Parliament is having such powers or not. And I'm sure considering further amendments being made, if we see Article 248, which was amended by the same Parliament by making amendment in 1972, and it was also confirmed and clarified that yes, the Parliament was having such rights. So since there was no permanent nature of Constituent Assembly of J&K, and hence this kind of amendment was very much possible, and accordingly, by following due process of law, it has been amended. And I'm sure the same observations will come in the judgment.
So today, you are saying that due process has been followed and there is a certain level of due diligence. The former President Ramnath Kovind himself is a very, very amenable mind with a seasonable amount of experience with, as far as law is concerned and legal practice is concerned. But Kapil, Madan, your point of view on this?
So Anand, one thing is very, very clear. The basic premise of the challenge is that, we all know that when 370 was introduced, it was a temporary provision. And since the Constitutional Assembly was dissolved, it is argued that it became permanent. So the issue before the Honorable Supreme Court in nutshell is whether the Parliament has an amending power to amend 370, because it was temporary at that point in time. The moot question which the Honorable Supreme Court will be discussing would be whether this amount.
So how do you define temporary, sir? How do you define temporary?
Alteration of the basic feature.
How do you define temporary? Temporary is 2 months, 3 months, 5 months, 10 years, 15 years, 70 years, 75 years. What is temporary?
No, I don't define temporary. No, I don't define temporary. What I am saying is that it was being argued by the petitioner in the Supreme Court, and now it is for the Supreme Court to decide when the Constitution Assembly was dissolved, because there is a provision in the Constitution. If the provision is there, if if you want to remove the provision, there is a process that needs to be followed.
Yeah.
All I'm saying
So
is-
if
all
you
I'm
have to
saying
remove
is
the
that
provision, again, the same
Constitution
parliamentary
envisaged
procedure has to be
amendment.
followed. Arunima and Anusha with us. Rahul coming in just, we're just going to both Arunima and Anusha, who've been covering this since morning. They've all spoken to all sides of the spectrum in terms of those who have argued for and against 370 and petitioned in front of the Honorable Supreme Court. Anusha, first coming across to you. Legally, those people who have in the past politically said that 370 has been diluted over the years, today are saying 370 should have not gone in this manner. And they are already saying this battle is lost.
Well, Anand, all I can tell you is that the procedure by which the government has amended this particular provision, and something that Rahul was also pointing out, that there is a constitutional precedent for it. The case that Rahul was talking about is the case of Muhammad Maqbool Damnu versus J&K. And in that particular case, the term Sadre Riyasat, it was substituted by the term governor. If you look at the history ever since the accession of the erstwhile territory of Jammu and Kashmir to the Union of India, the erstwhile state, there have been multiple changes that the government of India has made, and all those changes have been via Article 367. That particular article forms the tool, the procedural article through which you make changes. Now the argument of the petitioners is the change that you have made is constitutional in nature and vitiates the basic structure of the constitution. Is that something the court is going to accept? That's a wait and watch. And second point, very briefly, is also about the powers of the president under 356.
Right.
That the president, without the consultation of the legislative assembly, could not have done that, and the will of the people was not really taken into account. The two moot arguments that have been presented before the court.
Well, when we talk about the basic structure doctrine, and which is invoked so often, and I must say that she's really done her homework here. Let's also not forget that the basic structure doctrine promises equality to all citizens of this country of all their basic rights. Now, you know that this Article 370 actually discriminates on the ground between various kinds of citizens in Jammu and Kashmir. So you have certain sections of our society completely at one level suppressed and consigned to doing menial jobs. The NHRC's writ is not extendable to that particular state till, of course, recently. And I think where, we forget, and I think that has been pointed out right now, is that 54 occasions, on 54 occasions, presidential orders have been passed to extend the provisions of the Indian Constitution to the state. So already 54 occasions, this presidential orders have been passed to invoke certain powers.
But there the counter argument only, and just playing the counter here, Rahul, is that when in these 54 instances when presidential orders were passed, was the Legislative Assembly of Jammu and Kashmir onboarded at that time? Was there a government that was so-called elected government there and which ratified these presidential orders and confirmed to implementing them?
So what does Article 373 state? In the Constitution, it clearly states that the President may, by public notification, declare that this article shall cease to be operative. Now, the following three words are, provided that the recommendation of the Constituent Assembly of the state shall be necessary before the President issues such a notification. Now, of course, the Constituent Assembly was dissolved, stood dissolved in 1957. The Legislative Assembly was in place, but there was obviously governor's rule. Okay. And we know that once there is governor's rule, it comes all the way back to the president's.
That's what they're saying. See, when the argument was not there, Arunima, coming back to you, where you spoke to petitioners from both sides. One of the aspects is, now they are saying that this was supposed to be done with the Constituent Assembly, and there is no Constituent Assembly. That means 370 becomes permanent. That's the argument. The other argument is that we interpreted conveniently Constituent Assembly as Legislative Assembly till the time 370 was abrogated. So till then the local government in power acted as the Constituent Assembly despite the fact that it's been a Legislative Assembly since 1957.
Yes, the government has argued that the parliament was well within its right. The Constituent Assembly, is something when, the parliament decided to legislate on 370. It was in sync with what the constitution had said. The petitioner's argument is, like you're pointing out, that the Constituent Assembly's is equivalent to the Legislative Assembly. The central government's argument is that the Parliament has that power. The second question to be debated is that since an instrument of accession was signed, is Jammu and Kashmir then not similarly placed as the other states? Does it then retain its sovereignty? So all of these questions are before the Supreme Court. But the petitioners, the sense that I get after speaking to them is that the bigger concern, the bigger relief that they seem to be expecting is on the question of statehood. The government itself is committed as far as the statehood question is concerned. They have said that we will restore statehood. When is a matter of time. The Election Commission will have to decide that. So I think the petitioners are keener to see if the Supreme Court sets a timeline, if it gives any instructions to the government that you must do this in this particular timeline. Other than that, as far as 370
it's not
is
about
concerned,
hindsight.
most of the petitioners...
It's about what's the way forward. How soon can we go back to becoming a state? So that's where the petitioners are looking at. So they have decided
yes, I think realistically, Anand, there is more or less this acceptance. Realistically, from the sense that I get from the petitioners is that it will be difficult for the Supreme Court to turn the clock back.
No, so not just clock back, even question the legality of it, because the President's office had vetted it, the Home Minister's office had vetted it, and the Parliament has ratified this. And that also, at that time, the arguments were largely political, saying, how can you allow 370 to go? Because many thought 370 will never go. Although those very people said 370 has been far diluted. Just about 1 minute on the clock before the verdict begins, we got visuals coming in from the courtroom. It's all in camera, so everything is now broadcast. The days have changed, times they have changed so much. Earlier, nothing from the court could be quoted. Now everything from the court can be seen and heard. Farooq Renzusha is with us. Farooq Renzusha ji, what do you expect?